Business before the Honorable, the Supreme Court of the United States are admonished to draw near and give their attention.
Landmark Cases, C-SPAN's special history series, produced in partnership with the National Constitution Center, exploring the human stories and constitutional dramas behind 12 historic Supreme Court decisions.
Mr. Chief Justice, and may it please the Court.
Quite often, and many of our most famous decisions are ones that the court took that were quite unpopular.
Let's go through a few cases that illustrate very dramatically and visually what it means to live in a society of different people who help stick together because they believe in a rule of law.
Good evening and welcome to C-SPAN's Landmark Cases. Tonight, Brandenburg versus Ohio. This 1969 case, the Warren Court unanimously handed down one of the most expansive interpretations ever of our First Amendment guarantees to free speech and assembly. Nadine Strawson, as we start, what are the very basics of this case?
Clarence Brandenburg was the leader of the Ku Klux Klan in Cincinnati, Ohio, who held a rally for his small group of followers only, invited some members of the news media to attend the rally. They filmed it and aired it on TV, showing him in a hood, Klan regalia, in front of a burning cross. Some members of his organization were brandishing guns, making racist statements about Jews and blacks. And he was convicted and sentenced 1 to 10 years under an Ohio statute that made it a crime to advocate violence as a form of social change.
Obviously, for the next 90 minutes, we're going to dig into the particulars of this case and learn about its impact on our society. But as we get started, we have two pieces of media for you. We're going to listen to a little bit of the oral argument in the case, and you'll hear some of the particulars of this case, as Nadine Strawson just told us. And please do note as you hear it, it includes some of the offensive language used by the defendant in this case, but it's at the heart of what we're talking about tonight. And then we move on to Justice Ginsburg, then Judge Ginsburg, in her 1993 confirmation hearing, where she talks about the case's importance.
Then there is a second portion of the film in which a group of people are walking or marching around a burning cross, hooded, armed, shouting profanities, in which there is a question whether or not the defendant himself said the words as attributed to him in the transcript and on page 5. How far is the nigger going to, yea, send the Jews back to Israel, and so forth, with the other profanities.
Brandenburg against Ohio truly recognizes that free speech means not freedom of thought for those and speech for those with whom we agree, but freedom of expression for the expression we hate. I think that there are always new contexts that will be presented, but that the dissenting positions of Holmes and Brandeis have become the law that everyone accepts. I think that is the case today.
Would you consider Brandenburg as one of the great milestones in the court's history?
I certainly do, yes.
Katie Fallow, as Justice Ginsburg said, there are always new contexts. So there were First Amendment cases before this, and there seemed to have been quite a number after it. What is it about the Brandenburg case that makes it seminal?
Well, I think I agree with Justice Ginsburg about, in sort of two fundamental respects, that the Brandenburg decision both is one of the strongest protective decisions of free speech, and it's been around for nearly 50 years. And it establishes a fundamental principle that we need to allow free speech even if it's extremely offensive or even if it advocates unlawfulness. And I think that the other aspect is it's very important because it means that we are sometimes going to have to tolerate speech that we find personally repugnant.
Let me tell you a little bit more about our two guests at the table, and they'll be with us to help us understand this case. Nadine Strawson is former president of the ACLU. She served in that position from 1991 through 2008 and was both the first woman and the youngest person ever to hold the position. She's now a professor at New York Law School in Manhattan. She's also got a new book out which is completely relevant to our discussion tonight. It's called Hate: Why We Should Resist It with Free Speech, Not Censorship. Katie Fallow is a senior attorney at Columbia University's Knight First Amendment Center. She's a former partner at a private law firm, Jenner & Block, where she wrote a brief on a First Amendment case, EMA versus Brown, which held that video games were protected speech. She also clerked in the federal courts for Judge Rosemary Barquette of the 11th Circuit, the U.S. Court of Appeals. Welcome to both of you.
Great to be here.
Okay, we're going to start with the history. This all concerns a set of laws called the criminal syndication laws. I told you I was going to have a hard time with that. Syndicalism laws. And in fact, many states had them. What is the history of them? When did they all start developing in this country?
They were adopted starting in 1919, the World War I era, as a response to the spread, or the feared spread, of anarchy and communism and socialism.
And did they all basically do the same thing?
Pretty much. So the language in the Ohio statute was quite typical, that it criminalized any advocacy of violence that was directed toward bringing about social change or economic change. And they also used the word terrorism.
It's interesting that our case that we're looking at deals with the Ku Klux Klan, but this really was a fear of communism that got this all started. So can you add any more history to what the country was worried about as all these states were passing laws?
Yeah, I mean, I do think the Brandenburg case in general is interesting because it reflects a lot of social changes and cultural fears and transitions that are happening throughout the 20th century. So, as Nadine said, these laws started to be passed in many states as a result of fear of communism and the international workers of the world, and concerns about a threat to capitalism from communist sympathizers. And I think there was some sentiment about fear of immigrants bringing in sort of ideas from the outside to try to attack capitalist democracy.
There were three key cases that the Supreme Court dealt with before Brandenburg. One of them we talked about in our first session of landmark cases, Schenck versus Ohio, which was in 1919. And that's famous for the phrase clear and present danger. Two other cases, Whitney versus California in 1927 and Dennis v. U.S. in 1951. Why are these cases all part of the lesson we need to learn about Brandenburg?
Well, basically what all of these cases have in common is they dealt with one of the greatest fears of potential harm that free speech could cause, namely bringing about harm to our capitalist system or to national security more generally. And the Schenck case was famous because it was in that case that the Supreme Court, in an opinion through Justice Oliver Wendell Holmes, came up with a famous test, the so-called clear and present danger test, that speech could only be punished if it satisfied what sounds like a very tough standard, but in fact, as it was actually enforced by the court in that case and the other two you mentioned, Susan, allowed government to punish speech that presented neither a clear nor a present danger, but allowed it to suppress political speech that it disagreed with, that criticized the status quo and challenged it.
What more do you want to say about these cases?
Yeah, well, one thing that's very interesting about the Schenck case and Justice Holmes' role in it is that he was the writer of the Schenck case, and he established this test of clear and present danger, and which upheld the conviction of socialist leafleters. But then within, I think, just a year, he changed his mind, and he was in a dissent in another case where he dissented from upholding the conviction of communist sympathizers, and he and Justice Brandeis started developing a much richer doctrine of free speech protection, but for many years in dissent, not in the majority.
All of these cases, of course, are tests of the First Amendment, and we're going to pause for a moment and actually revisit the First Amendment to the Constitution. It says, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press or of the right of the people peaceably to assemble. and to petition the government for a redress of grievances. Can either of you give our audience a little bit of background on what the founders were thinking as they drafted this and why it was the First Amendment in the Bill of Rights?
Well, I think that the founders considered the right to speech as fundamental to the American system of democracy, the ability of people to debate matters of interest and to become informed for their ability to exercise their political power as well, and recognized the importance of letting truth hopefully bubble up from wide open debate. But it's interesting that in some of these, in this case of the Schenck case in 1919, prior to that, the Supreme Court had not struck down any law as violating the First Amendment. And the First Amendment, I think, was the right to free speech was considered more important just to prevent against prior restraint, where the government would actually prevent someone from saying something in advance. But there had been no cases holding that a certain law had violated the First Amendment.
When you teach First Amendment law and history to your students, what do you tell them is most important?
Well, I actually go back to the very first words in the entire Constitution, right? We the people, in order to create a more perfect union and so forth. So we the people are the governors in our democratic republic. How could we possibly carry out that important responsibility unless we had the most robust freedom of speech, including to criticize government officials and policies and each other in very strong language? So you can't separate out freedom of speech from our overall democratic political structure. But it's also really important for individual self-fulfillment. And Justice Brandeis, who was one of the great dissenters that Katie alluded to, and whose essentially dissenting opinion in the Whitney case was reaffirmed by the Supreme Court in the Brandenburg case because they overturned Whitney. They embraced his dissent. He said that freedom of speech is important both as an ends and as a mean. The end in itself is individual liberty to choose ourselves what we will say, hear, listen to, or not. But it's also a means to democratic self-government.
If they were having a robust discussion about what free speech meant in the 1919 and 1920 era, we continue to have one of those in our society today. So we hope you'll be part of our discussion tonight and go with us on this journey as we learn about this important case. There are a number of ways you can do it. You can call us, and here are our phone lines. If you live in the Eastern or Central time zones, 202-748-8900. If you live in the Mountain or Pacific time zones, 202-748-8901. And we'll put those numbers on the screen throughout our 90 minutes together. So as questions come to mind or comments that you'd like to share with us, our two guests here, please do so. You can also be part of the conversation on Twitter. Write to @CSPAN and use the hashtag #LandmarkCases. We've had a really enjoyable conversation on Twitter throughout our series, and we hope you'll be part of that this evening. So Ohio's I cannot do this thing. Criminal syndicalization statute. I'm not going to say it again, okay?
CS will do.
We'll do CS. The 1919 case. Let's look at what it's specifically prohibited. It made illegal advocating, quote, the duty, necessity, or propriety of crime, sabotage, violence, or unlawful methods of terrorism as a means of accomplishing industrial or political reform. Voluntary assembling with any society, group, or assemblage of persons formed to teach or advocate the doctrine of CS. As lawyers, what do you hear in that statute that would come against people's actions at that time?
I mean, I think one of the ways that these laws were used were to punish people who were advocating or even just teaching about political doctrines that would involve industrial revolution. I mean, communist revolution, and that was the concern about whether or not these laws could be applied, like in the Whitney case, where the Charlotte Whitney, who was, I guess, a grand niece of a former Supreme Court justice from a prominent family, and she had attended convention of the Communist Party, and she was a member, but she was essentially convicted for being a part of the Communist.
And as I understood it, she opposed the position that they should use violence. She was advocating sort of what we would call today democratic socialism. And in his great concurring, it was called a concurring opinion, but it really sounded like a dissent. Justice Brandeis said, you know, the fear of revolution or some other violent or lawless event can never justify censorship. Men feared witches and burned women. And I thought that was such a great line, especially when it was a woman who was convicted in that case.
So in Ohio, voluntary assembling with any society group or assemblage of persons formed to teach or advocate this doctrine. So just by attending a meeting
And literally teaching. I mean, in the Dennis case, it was just a matter, it was leaders of the Communist Party, and they were convicted for teaching what are classic works of Marxism and Leninism that are taught in many college courses.
So the other thing that we should talk about is the Ku Klux Klan. At the 1920s, 1910, 1920, 1930, at its height, the Klan had 2 million members nationwide. By the time we get to 1964, 1965, when this case is germinating, what's the Klan like in the United States, and what's kind of the societal attitude towards the Klan?
Well, I mean, I think at the time, obviously, it was right in the middle of the civil rights movement. And so at the time, it was an extremely volatile and important social change. And people were really talking about and fighting against the kind of terrorism that the Klan had perpetrated against Black Americans throughout for nearly 100 years. So I think it was extremely important, and clearly animating this case is the background of the Klan's violence and terrorism.
News media reports suggest that although the Klan had, according to the FBI and other authorities, about 40,000 members in this time period, that there are as many as 200 bombings that may have been perpetrated by members of the Klan or their sympathizers, and of course there's a murders of many civil rights workers. So this is the background of this case.
I think it's also important to remember, though, Susan, that at the same time we had a growing anti-war movement, plus of course the civil rights movement to which Katie alluded. And I think the Supreme Court probably was concerned about rights of demonstrators and protesters advocating various kinds of changes, both for civil rights and against civil rights. Certainly their decision was one that has protected the rights of civil rights advocates.
We're going to learn about Clarence Brandenburg, who gave his name to this case, but we've got some callers on the line. Let's begin with Jonathan from Milwaukee. Hi, Jonathan, you're on the air.
I would like to know if you could please explain how the Supreme Court in the Brandenburg case combined Judge Learned Hand's direct incitement test in the Matz's case with Justice Holmes's clear and present danger test that was first articulated in Schenck and later developed in his Abrams dissent and in other cases. Thank you very much.
Jonathan, you sound very learned, but I will put into paraphrase for the other listeners what you clearly know, which is the reason why this is such a speech protective test standard, as Katie said earlier, is that it took every speech protective element in prior Supreme Court decisions and said, one of them alone is not enough. You have to satisfy all of these standards, government, as a prerequisite for suppressing speech. You cannot do so unless you can show that it is an intentional incitement of imminent violence, which is likely to happen. In prior tests, the Supreme Court had said one of those elements or two of those elements was enough, but it's very hard to satisfy all three appropriately.
Josh is in Algona, Iowa. Hi, Josh. Watching our series from time to time. Nice to hear from you. What's your question tonight?
Yes. Thank you. Since both Justice Douglas and Black were almost First Amendment absolutists, how influential were they in the final decision of this case?
I mean, I think from what we know, I mean, one interesting thing about this decision is that it was a per curiam decision, which means it came from the court and wasn't authored it wasn't attributed to a particular justice, and it was a unanimous decision. All 8 justices that were then on the court joined it, and they wrote separately just to emphasize that whatever the majority per curiam decision said, that the court should not and was not in any way embracing the previous clear and present danger standard, because whereas Justice Holmes wanted that standard to have teeth to it and use it as a way to only be able to punish speech that, in fact, is an emergency, is an emergency situation, that the standard had been used in ways that could actually be applied very vaguely to, in the Dennis case, just apply to people who were teaching Marxism and Leninism. So Black and Douglas wrote separately, really to emphasize that the clear and present danger standard was being abandoned.
And I've read that initially the opinion had been assigned to and was drafted by Justice Fortas before he retired from the court, and he had language that was similar to the past clear and present danger standard, and Justice Black said he would not sign the opinion unless that language came out. Fortas left the court. Brennan was the one who apparently redrafted it and did take out that language and came out with the much stricter test that Brandenburg included.
Jim is in Caliente, California. Hi, Jim.
Hello. Thank you very much. My question is regarding free speech today. So much activity in speech is on social media. Social media is these are private companies. And yet it seems to me that if you restrict speech on them, you are restricting a great deal of speech that's going on. And with the Facebook situation has recently come up, I'm just wondering what thoughts you might have on how we make sure free speech is carried through to these entities, whatever they are. They're so new, I don't know how you quite describe them. Anyway, thank you.
That's a great question. Well, first of all, the Supreme Court unanimously in June decided a case in which it held that government may not deny access to social media to an individual. In this case, it was a convicted sex offender who had served out his time. Precisely for the reasons you state, Jim, the Supreme Court used very strong language about what an incredibly important public platform this was, especially for getting news and information and sharing it. Now, the harder question is, what about the censorship by social media themselves? As many people are surprised to learn, the First Amendment does not directly apply to private sector entities, and yet for all practical purposes, the social media are, one commentator said, exercising more censorial power than all of the governments in all of the countries around the world throughout history. And I think it is a very serious concern.
Steve is in Laguna Beach. Hi, Steve. You're on the air.
Thank you so much. First of all, I want to thank C-SPAN for this wonderful series, the second year of it. It's just been fantastic to watch. I wanted to ask the speakers about the free speech movement in the 1960s, which started at, I guess, UC Berkeley, and how it's evolved now to on campuses where there are attempts to censor speakers coming on with opinions that may be offensive to some of the students there. And how does Brandenburg apply to those situations, particularly at public universities?
Well, I think that I did go to Berkeley, so but a little bit later than when the free speech movement started. But I mean, I think that the current controversies about free speech on campus, that if it is a public university, they do have to comply with the basic First Amendment requirements that allowing speech and not discriminating or denying speech based on viewpoint, and to not allow speech, to allow speech unless it is going to, in fact, incite imminent lawlessness. But obviously, that's created a lot of thorny problems. On the other hand, one way you can look at speech on campus is actually there's a lot of free speech happening, and certainly when I was at Berkeley, it's just it's more of a fact of life and a part of everyday life that I think is good, including the counter speech against people who, the counter speech meaning speech by people who are disturbed by the by hateful speech and those students' rights to speak up.
Jeff is watching us in Boston. Hi, Jeff.
Hi, thanks for taking my question. So recently I've read about a college student that made a posting on social media that had some racist connotations, even though it wasn't even intended to be so. And the University of Kansas State University expelled the student. And in a separate case, I read about a couple of high school students that expressed themselves in a way that seemed racist, and their public high school expelled them. How is that possible?
Well, I hate to shock you, Jeff, but a lot of government officials, including on campuses and high schools, do things that violate the Constitution. It was not self-enforcing. As Katie said, the Supreme Court never really enforced the First Amendment at all until well into the 20th century. No provision in the Constitution is self-enforcing. It takes advocates such as the Knight Institute and the ACLU and clients who come to them to be able to actually translate the theoretical freedoms of the First Amendment into reality for real people.
It's a good time to tell you that our next case is Tinker versus Des Moines School District, which is about student free speech and so relevant to so much of the discussion on campuses, high school and college campuses today. So let's pause and learn more about Clarence Brandenburg, who gave his name to this important First Amendment case. I'll tell you a little bit about him. He was 48 years old at the time his case went to the court, but he was an unhappy person with his life circumstances. In 1958, he was laid off from the local General Electric plant where he worked and threatened to sue the company for that. He went back to his television repair business, and by 1959 had to declare bankruptcy for that. In the summer of 1963, he attempted to take over the local white supremacy group, the National Association for the Advancement of White People, and that was the context for him and the event for which he was arrested. Now, here is the timeline of his case. And it was June 28th, 1964, when he organized and then also spoke at a KKK rally outside of Cincinnati in Ohio on a private farm. And I'm going to talk about that importance. What was also significant is that it wasn't just that group of people. As Nadine Straussen said, that he invited local media, and in fact, a station in Cincinnati, WLWT, came to film the rally. In August 6th of 1964, he was arrested at his TV repair shop. In December of 66, they had trouble apparently seating a jury on this case. He was convicted under the 1919 Ohio law. He appealed that to the Ohio Supreme Court, and that was rejected. And on January 6, 1967, Clarence Brandenburg was sentenced to 10 years in prison and a $1,000 fine. Now, he could have gotten even higher fine, so the court was a little bit lenient looking at that. So what's important to know about that timeline?
Well, I will say one thing about Clarence Brandenburg, to paraphrase Justice Frankfurter, that many safeguards of liberty have been forged by people who are not very nice, essentially. And I think that that's, one of the things we were talking about is sort of what was the membership of the Klan at the time. Even Clarence Brandenburg's lawyer referred to his client and his client's cronies at this rally as kind of silly and absurd, that they didn't really make a big impact. It wasn't widely attended, et cetera, but yet you still had the historical context and the background of the Klan's role.
And I think that the fact that the civil rights and the historic 1964 civil rights statute was about to be enacted, it was signed into law just a few days after his speech on July 2nd.
So what was it significant that this was on a private property?
Very much so, because it would be very difficult to argue that anybody could feel intimidated or threatened by the expression because they didn't know that it was going on. It was not aimed at them. It was also a rally among supporters. So it was like a membership meeting of people who all shared the same view. exercising their freedom of association as well as their freedom of speech.
You mentioned in the description that some people brought guns. Was that an important thing for the Ohio authorities?
The Supreme Court didn't note it, Susan, and I think in under the statute it did not really make a difference because the statute criminalized mere expression, just conveying certain ideas, advocating certain ideas.
So when this case was appealed to the Ohio Supreme Court, a new lawyer by the name of Alan Brown came in. Now, the interesting thing about him, he was Jewish, and many of Mr. Brandenburg's comments were anti-Semitic. Do we know anything about Alan Brown that's important to know in this story?
Well, I looked him up, and he was at the ACLU of Cincinnati for many years. He was a committed civil rights, civil liberties lawyer. He served in World War II and seems like an extremely smart and honorable man. And he did agree to take this case, even though Clarence Brandenburg himself was not thrilled to be represented by a Jewish attorney, but he, really felt committed to the cause of free speech.
I actually had the opportunity to meet him in Cincinnati in the early 90s. There were some incidents of censorship taking place there in what many of us call censor natty, and he and I were going to be on a panel together. His son also said that his father, who so neutrally defended free speech, for the most unpopular speakers all across the political spectrum, is the only person in whose office he saw both a Ku Klux Klan leader and a Black Panther leader.
So this is a part of the history of the organization you led for such a long time. We have a piece of video next to show that will be a familiar face to C-SPAN viewers, and it's Eleanor Holmes Norton, who for many years has served as the member of Congress representing District of Columbia as a delegate. But back then, she was an ACLU lawyer, national lawyer. We're going to listen to her talking about this case.
The ACLU had only 2 national lawyers, and I was one of them. So that if there was a case that was going to Supreme Court involving important civil liberties issue, like a First Amendment issue, the right to speak, for example, or to print, that had to come through the national office. So I was on the brief in the Brandenburg case. The 60s and 70s was a good moment in time for the court to look at what advocacy means and how powerful it can mean in change, in bringing change, and I mean positive change, to our country. Now, I can tell you, since I was in the civil rights movement, I thought that all of my colleagues who were also in what we call the Student Nonviolent Coordinating Committee would say, go get them, Eleanor, because after all, we need all the speech we can get, because we need it every day that we wake up. Instead, some said, what is Eleanor doing? If you talk to them now, they will tell you, and they've gotten as old as I have, that we understand what she was doing. But there was mixed feelings in the civil rights movement, even. The failure to make the connection between the neutrality of speech and that in a democratic society, it's very hard, unless the government makes a decision, to say who's allowed to speak and who is not. Now, do you want the government making the decision, or you want a free-for-all on speech? Well, I go for a free-for-all, and I mean, sometimes I got to defend people who would not defend me.
I'm sure you both have something to say about that. Nadine Strossen, we're going to start with you, since she was with the organization that you led for such a long time.
Absolutely. And I read an interview that Eleanor Holmes Norton did at the time of the case, and interestingly enough, she said she was very aware that even though she was defending the free speech right in the context of a racist, she was convinced that the main beneficiaries would be Black militants and other radicals whose views were seen as dangerous and threatening and subversive by many government officials all over the country. And in fact, I think those were major beneficiaries.
Yeah, echoing what Nadine said, I mean, if you look at Brandenburg, the times that the decision was applied after the 1969 decision was in the case of an anti-war protester in the Hess case, and then later on in the early 80s in the NAACP versus Claiborne hardware case, where on using Brandenburg, the court overturned the conviction of civil rights demonstrators who had threatened violence against people who were not adhering to a boycott of racist stores. So it has been in fact applied to people on all sides of speech spectrum.
Let's go back to calls. Bertie in Hagerstown, Maryland. You're on the air. Welcome.
Oh, hi. I wanted to talk about the doctrine of free speech exemplified by shouting fire in a crowded theater. And I was wondering, what is the culpability of a person who would intentionally seek out someone that they knew to be suggestible, someone who was very badly educated or emotionally unstable, and sat next to them in this crowded theater and goes, sniff, sniff, do you smell smoke? Wouldn't a fire be terrible? And, you know, I think I see a lot of this suggestion taking place in some instances.
Bertie, you have done what 99% of people do when they think they are paraphrasing that famous line from Justice Holmes, but you left out a very crucial word, which I think answers your question in large measure. He said that freedom of speech does not extend to falsely shouting fire in a theater and causing a panic, right? If the theater really is on fire, we want people to shout fire because it would be life-saving. But if, in fact, the theater is not on fire and it endangers people by falsely telling them it is and creating a panic, then that truly does satisfy this notion of a clear and present danger that would justify suppressing or punishing the speech.
Yeah, and I mean, I think that example of falsely shouting fire in a crowded theater is an example that would satisfy the Brandenburg standard. That it was intended to incite and likely to incite imminent lawlessness or, a riot or harm.
Janine is next, Danville, Kentucky. Hi, Janine. Welcome.
Oh, thank you for taking my call. I've heard this term, compelling government interest, as a way to limit speech on a college campus, and I was wondering if your guests could explain the term and tell me exactly what evidence is required to establish a compelling government interest. Thank you for taking my call.
That's another legal formulation similar to the Brandenburg standard, but you've only given one part of it. The government would have, including a university official, would have to show not only that that there was a compelling interest at stake, but also that suppressing the speech was necessary in order to advance that interest. So if it's an emergency, and nothing short of censoring the speech is going to prevent that emergency, then and only then may the government suppress the speech. But if there's any other way of preventing violence, for example, that the speech threatens to imminently cause, for example, the police can come in and protect against the violence. Censoring speech has to be a last resort.
We're learning about the history of a landmark First Amendment case at the Supreme Court, Brandenburg versus Ohio. Our next caller is Basil, North Olmsted, Ohio. Welcome.
Thank you. It is Basil. It seems to me that the term legal system and man is not above the law are kind of contrary to the truth, because it is man in this country that makes the laws. To me, morality and truth have nothing to do with the law, in my opinion. I'm an octogenarian. And every time a law is created, a criminal act is added on the books. You do not make a law unless there's a punishment attached to it. And to me, the legal system has become a noose around the American public's neck. Our prisons are filled with people because of laws that put them in jail that wouldn't have been there before. It's all right to murder if the law says you can abort a child, but you can't kill another man with a gun without going to prison. So I just have to say that the legal system better wake up to what you're doing to this society. I'm listening to you wonderful two ladies talking a lot of jargon and gibberish about First Amendment rights and Second Amendment rights. How about the truth, and how about a morality and law? Wake up, young ladies, before we go to hell in this country. I thank you for your time.
Thank you, Basil, for exercising your First Amendment right to dissent and criticize the law.
So let's move on to the Supreme Court in 1969. Clarence Brandenburg was first arrested in August of 64, so it took fully 5 years for his case to get to the Supreme Court. But this is what the court looked like in 69. The Eisenhower appointees, Chief Justice Earl Warren, John Marshall Harlan II, William Brennan, and Potter Stewart. The Roosevelt appointees, Hugo Black, William O. Douglas. The Kennedy appointees, Byron White. And Johnson appointees, Thurgood Marshall and Abe Fortas. We'll talk a little bit more about Abe Fortas's history in the court in that particular year. This was one of Earl Warren's very last cases. He retired on June 23, 1969, 2 weeks after the decision. So sum up the Warren Court for us. What was it noted for?
Well, the Warren Court was particularly noted for being upholding a lot of civil liberties and civil rights, particularly in the area of desegregation and other and criminal rights. I do think it's interesting with this Brandenburg case because it is at the very end of the Warren Court, and it certainly marks a very strong marker of protecting speech. But to some extent, the credit really for the development of the free speech principles has to go to the earlier justices of Holmes and Brandeis, because although this was a Warren Court decision, the principles that they adopted and established in this case really were developed further in a more sort of rich detail in those earlier decisions.
One of the other interesting stories about the justices in this case is Justice Hugo Black, who wrote one of the concurrences. And in fact, he was at one time in his earlier history a member of the Ku Klux Klan. He left in 1925. Remember earlier we told you that the 1920s was the height of Klan membership in the United States. Also a former U.S. Senator from Alabama. When he was appointed to the court in 1937, the Pittsburgh Post-Gazette did an investigation about his background, and Hugo Black did a radio address responding to that part of his history. We're going to let you listen to that next.
The insinuations of racial and religious intolerance made concerning me are based on the fact that I joined the Ku Klux Klan about 15 years ago. I did join the Klan. I later resigned. I never rejoined. I completely discontinued any association with the organization. I have never resumed it and never expect to do so. At no meeting of any organization, social, political, or fraternal, have I ever indicated the slightest departure from my steadfast faith in the unfettered right of every American to follow his conscience in matters of religion. I number among my friends many members of the colored race. I have watched the progress of its members with sympathy and admiration. Certainly, they are entitled to the full measure of protection accorded to the citizenship of our country by our Constitution and our laws. Some of my best and most intimate friends are Catholics and Jews.
Let's ask both of you what this part of Justice Black's background, what you know from studying him in his role in the court, that he brings to his thinking on this case. What's important to know about it?
Well, first of all, in defense of Justice Black, he apparently joined the Klan at a time when that was just the done thing in politics in Alabama. He was one of the greatest defenders and champions of racial justice that the Supreme Court has ever seen. And as one wit put it, when he was a young man, he put on white robes and scared black people. When he was an old man, he put on black robes and scared white people. And he has left a real legacy for both freedom of speech and equal rights.
Yeah, I echo what Nadine says, and I don't think his last statements. Generally when you say some of my friends are black people or Catholics or Jews, it seems like it's sort of a faint excuse. But I think in his actions and his votes on the Supreme Court, he absolutely showed his commitment to racial justice. And in this case, he also, as noted before, with Justice Douglas, took a particularly strong concurrence to make sure that the incitement standard was really strongly enforced.
So the case was heard by the Supreme Court. The oral argument was on February 27th, 1969. Richard Nixon, President of the United States at that point. And as we mentioned earlier, the lawyer arguing on behalf of Clarence Brandenburg was Alan Brown. We're going to listen to a little bit of his oral argument, and I'm going to have our guests talk about the legal principles he was trying to convince the court about. Let's listen.
These are the facts in this case. A television reporter received a telephone call indicating that if he wanted to, he could come and take movies of a Ku Klux Klan meeting. He came. He met some hooded figures, and arrangements were made for the taking of a movie. A movie was taken in which a cross was burned, some figures milled about and yelled some stupid and rather senseless slogans, and then a single figure was panned in on who made a speech full of conditions, precedents, and reservations, and hyperbola, self-evidently stupid and silly. Another film taken is inside a house.
There were guns in this first.
There were guns in both films.
In both of them.
In both films, there were guns. It is also to be noted that the film was taken on a remote, private farm in which apparently there is no evidence whatsoever that these people were not invitees present on that farm by authority of the ownership of the farm. The case came on to trial. The state produced nothing but the film in question. The only other evidence that the state produced was basically geared to identifying the personnel involved in the film. In other words, showing that the man Brandenburg had a gun similar to the guns in the film, and that he had markings on his person similar to the markings, and that his voice was similar. Other than this, the state offered nothing.
So, what do you think about the argument he's making to the court?
Yeah, I think everything that Alan Brown is doing is showing that this video and this rally really amounted to nothing. It was silly, it was stupid, and what he's trying to establish is that nothing in this speech that was the basis for his conviction showed an intent to cause violence or was likely to cause violence or would create a clear and present danger of violence. So he emphasized it was a private farm, there was no one there but the people who were invited, and really emphasizing the facts that there was no other evidence of a broader effort to create immediate violence.
But in fact, as we looked at the text of the Ohio statute before, was he in fact rightly found guilty of that, the way it was written?
The statute was written so broadly that in effect it was creating a speech crime or a thought crime, punishing you because of disapproval of your ideas.
What is the court's role also when there's as many as 33 states that have similar laws on the books, but then 14th Amendment, there are states that don't? So how does that play into their thinking?
Well, it's kind of interesting, Susan, because the decision could have been written very narrowly. And I think Alan Brown's argument was saying to the court, look, he wasn't even advocating violence, right? On the very narrowest grounds, the court could have reversed the conviction by saying, we'll assume for the sake of argument that this statute is constitutional. We don't have to reach that issue because he didn't even violate the statute as written. Instead, the court went much further and struck down that whole statute and by implication all of the others around the country.
We're going to listen to some of the oral argument on the other side, and then we'll return to some of your phone calls. The state of Ohio sent Hamilton County prosecutor Leonard Kirshner to represent their interests before the Supreme Court. Here is a portion of his argument.
I believe that the Ohio criminal syndicalism law is constitutional. I have cited various authorities relative to my beliefs in this matter in my brief. I believe that the basic matter before this court is the application of the evidence as was presented to the jury to determine whether or not there was sufficient evidence upon which a jury could return a verdict. I believe that in this case, when counsel says sending the Jews back to Israel, let's give them back to the dark garden, that this might not involve violence. I would like him, perhaps in his reply, to explain how the statement, "bury the niggers," quote unquote, would not constitute a violent form of action.
So the Ohio attorney is suggesting what about his language and its intent?
Well, he's suggesting that it could cause violence, but interestingly enough, since there was no evidence in that case, he had to come up with a hypothetical. And he said, suppose that Clarence Brandenburg had said, bury the Negroes in Harlem, to which Justice Thurgood Marshall, the first and then only African-American justice on the court, said, well, he wouldn't survive long if he said that. And Alan Brown, the ACLU lawyer, in his rebuttal said, by the way, that statement by Justice Marshall, if made in Ohio, could itself violate the Ohio I can't do it either, criminal syndicalism law, because it may be seen as encouraging violence against the speaker, against Brandenburg.
Katie Fowle?
Yeah, I think what Kirshner was doing in his argument was sort of the opposite of what Alan Brown was doing, was trying to emphasize the facts that showed that there was a broader effort to stir up violence and unrest, both from the incendiary nature of what Brandenburg said and the fact, and the court has a fair amount of back and forth about this, that Brandenburg had actually invited the media in and invited the television network. And what Kirshner argued was he wasn't just speaking to the 12 people or, so on the farm, he was actually trying to broadcast it into the broader community, and that would create a greater danger, a clear and present danger of violence.
Back to calls. Next up is Bill in Oak Creek, Wisconsin. Hi, Bill. Welcome.
Hello?
Yes, sir. You're on the air. What's your question?
My question is, does Brandenburg overturn, I believe it was called the Sedition Act that was enacted during World War I, that you could not speak out against the war or mail anything during the war? Or do them laws still apply? Because I think recently people had brought that up during the Gulf War and so forth.
It did not directly overturn that law, Bill, and it's an excellent question. One could make very strong arguments that the reasons in this case and other speech protective decisions by the Supreme Court would weigh in favor of overturning the sedition law if anybody ever challenged it in court. But to the best of my knowledge, that hasn't happened. Do you know anything more, Katie?
Well, is the Espionage Act the same as the Sedition Act? No. Okay, so I don't know. I know the Espionage Act, the Federal Espionage Act, which also prohibited advocacy of violence or unlawful acts, and also prohibited certain acts that would undermine the war effort, is still on the books.
And was that used?
And has been used, since 9/11 and in the war on terrorism and against leakers of leaking information that could aid a foreign country.
James is in Morristown, New Jersey. Hi, James.
Hi. I just had a quick question. Interestingly enough, just today, I believe the white supremacist Richard Spencer was banned from utilizing Facebook. And I was just wondering if there's any First Amendment implications to something like that.
The First Amendment, along with virtually all rights guarantees in the Constitution, only binds government officials. Facebook, as a private sector entity, therefore, is not constrained directly by the First Amendment at all, and under its terms of service, quite to the contrary, it pledges to block certain speakers and certain expression that a government official would violate the First Amendment by blocking.
Ben is up next in San Diego. Hi, Ben.
Hi. So my question is particularly for Nadine Strawson. I was wondering, are you familiar with George Lakoff's post about hate speech not being free speech?
I've seen many such misstatements, yes.
Yeah. Okay, well, just to summarize it, he says that hate speech is a physical imposition because language has a psychological effect imposed physically, bringing about toxic stress, fear, and distrust, which are all physical in one's neural circuitry, and that it can change the brains of those with mild prejudice, moving them toward hate and threatening action. Quote, when hate is physically in your brain, then you think hate and feel hate. You are moved to act to carry out what you physically in your neural system think and feel. And that's the summary of why he says hate speech is not free speech. I was wondering your response to that.
It certainly is true that expression is very powerful, and hate speech, which I'm going to put in air quotes because it does not have a specific legal definition, but let's say hateful, insulting speech on the basis of certain demographic characteristics, certainly can have potentially have adverse psychological and even physiological impacts, but not necessarily. It all depends on many, many factors, including the attitude of the person at whom the speech is targeted, right? So psychological experts, among others, say that we can train people to respond in a way that is empowering. They rise above the insults and they don't feel demeaned by that speech. Rather, it's the person who is uttering such hateful venom that should be the person that is looked down upon. And moreover, even if there is an adverse emotional or psychological response by a particular target of speech, that can never be a justification for censorship. Just think of the implications. All of us are subject to all kinds of expression that causes adverse emotional impacts, including expression about very important public policy issues. Our democracy couldn't survive if every time somebody had psychic pain, and I don't mean to diminish it, but I'm just saying the cure of censorship is even worse than the disease of some psychic pain, especially when we can all learn to be resilient and avoid that pain or minimize it.
Katie, you're nodding. You want to add for that caller your thoughts?
Oh, well, no, I was going to say Nadine wrote the book on this, but, I think absolutely that hate speech is not defined, and so and if you start going down the road of trying to have the government censor it in some way, it becomes extremely complicated and can't be applied. No one can agree what constitutes hate speech, so it's hard to censor it. But also to be clear that there are areas of law where the government can punish hate speech that's directed as a true threat against an individual. So it's not that there's no protection against things that really put someone in fear of bodily harm.
I think that's a great point. So just as it's, the generalization hate speech is not free speech is wrong, the generalization that all hate speech is protected is also wrong. Our law draws wonderful nuanced distinctions, such as in the Brandenburg case. If hate speech intentionally incites imminent violence that is likely to happen, it can and should be punished, consistent with Brandenburg.
Mark is in Millville, Pennsylvania. Hi, Mark.
Yes, good evening. I appreciate you taking my call. I'm looking for some guidance on employee speech, specifically for an employee at a public campus, for example. Do they enjoy the full range of First Amendment protections while engaging in speech on that campus, or are there limits in that regard?
Well, the employer, including a government employer, has the prerogative of restricting and regulating speech in a way that is necessary to maintain whatever the business is, in the case of a campus, an educational context. So if an employee said something that undermined the educational function of the university, that could be punished. But we would have to be very careful that it was not that power to maintain the educational function was not used selectively to punish certain ideas just because the university disapproved of or disagreed with the ideas.
The decision in Brandenburg was handed down by the court on June 9th, 1969. Next up, we're going to listen to Walter Cronkite of CBS announcing the decision on the nightly news.
In another case, the court overturned the conviction of a Ku Klux Klansman and declared Ohio's criminal syndicalism law unconstitutional. The ruling said a man cannot be punished merely for what he says if the words are not designed to incite lawlessness.
And that's the brief report on the national news. We said before that this was a per curiam decision. That means exactly what?
It means that it's just coming from the court. Typically, a single justice is assigned to write the majority opinion, the opinion that will govern the case. But in a per curiam, it's not attributed to any particular justice, and it seems fair to infer that the reason why this is a per curiam decision is because, as Nadine mentioned, it was first written by Justice Fortas before he resigned in a financial scandal, and then Justice Brennan then edited it. And at least some, scholars have reported that he really changed this language from the clear and convincing test to really make this new test of intentional incitement and likelihood of incitement.
This was a unanimous 8-0 decision. Are per curiams always unanimous?
No. In fact, I was surprised, to refresh my recollection in preparation for this program, that Bush versus Gore was a per curiam opinion. That was the one that ultimately resulted in George W. Bush becoming president, for those who don't remember. And there were many, many separate opinions that individual justices issued, but and the vote was as split as it could be, 5-4, and yet there was a per curiam opinion.
What was the story about Abe Fortas?
Well, it's complicated because there were some allegations that he had too close a relationship with President Johnson, with whom he had been very close politically, that continued after he was on the court, which was improper, violating separation of powers concerns and impartiality of a justice. And yet, as Katie said, there were certain financial allegations as well. I'm quite frankly not clear what it was that in particular propelled him to resign, but he had some financial relationships with some entities that were themselves being investigated for improprieties.
And had he been suggested as a possible Earl Warren replacement?
I'm sorry, all of this came out. He was nominated to become Chief Justice. There were hearings. Apparently it was the first time there were Senate confirmation hearings for that kind of elevation. And it was those who were opposed to him, perhaps ideologically, raising some of these other issues.
Here is an excerpt from the per curiam decision. We are here confronted with a statute which, by its own words and as applied, purports to punish mere advocacy and to forbid, on pain of criminal punishment, assembly with others merely to advocate the described type of action. Such a statute falls within the condemnation of the First and the 14th Amendments. Your comments?
Yeah, I mean, this was a watershed moment. The court had sort of inched towards that result, and there hadn't been that many Supreme Court decisions for nearly 20 years between the Dennis case and the Brandenburg case. But what they are saying is that mere advocacy, even of violence or unlawful action, cannot be punished under the First Amendment. And in later cases, there have been questions of what does this mean? What does the test mean? You have to intend to incite violence. It has to be it has to be imminent. The violence has to be imminent, and there's a question of what does imminent mean, and it has to be likely to incite violence. So you look at not just the text of the speech or the content of the speech itself, but also the context in which it takes place. How likely would it be to trigger violence? And you see in the case, the Hess case, which came up about 1973, maybe
72.
72 was an anti-war protester who had said, "We'll take to the effing streets later," and the court held that was not sufficiently imminent harm to uphold a conviction. So it's suggesting that even if violence were to occur even a matter of hours after the speech, that could not be punished.
There are two concurrences, Justice Black and Justice Douglas. Here's a bit of the excerpt of an excerpt from Justice Douglas. The example usually given by those who would punish speech is the case of one who falsely shouts fire in a crowded theater. This is, however, a classic case where speech is brigaded with action. They are indeed inseparable, and a prosecution can be launched for the overt acts actually caused. Apart from rare instances of that kind, speech is, I think, immune from prosecution.
Douglas, along with Black, was probably the most absolutist in terms of protecting freedom of speech. And Black, who joined in Douglas's concurrence, used to quote the First Amendment, which, as you read earlier, says Congress shall make no law abridging the freedom of speech. And Black would say, and Douglas echoed, no law means no law. And so they tried to make this distinction between speech and conduct, but not quite, because it's speech that is so closely tied or brigaded, as Douglas said, to conduct that the only way you can prevent the dangerous conduct is by suppressing the speech. But again, it has to be an emergency situation. It has to be suppression only as a last resort if persuasion or law enforcement doesn't do the job.
So as you both have said, what came out of this case, what became known as the Brandenburg test, you just referenced the three elements of it: intent, imminence, and likelihood. And Julia Ishishima on Twitter asks, can you discuss the intent element of the Brandenburg case? What kind of teeth have modern courts given it? Also curious about issues and challenges of imputing speech and intent of individual group members to the group as a whole, thinking here of Charlottesville.
Yeah, I mean, I think there's been a debate about, do you intend to incite a particular kind of violence, or do you just intend to give the speech? And there's been a debate about that. In terms of the events in Charlottesville, I think that that you have to look at what the speech that the individual protesters gave. The fact that they were going to have the protest, I mean, there's been discussion about that they were going to go there and they wanted to start violence. Things like that, and if people, and I think the ACLU has made the decision not to represent people who want to march with guns because of the concern about the imminence of violence, but you have to look at, on the other hand, you had all these protests after the Charlottesville rallies where people came and there were, white nationalists that were speaking, but it was peaceful ultimately. So you don't want to take these terrible events and try to use them as reasons to squelch any kind of speech, no matter how offensive it is.
And I think we have to be very concerned about guilt by avoiding guilt by association. That was really a play in the NAACP case that Katie mentioned earlier, where the Supreme Court, citing Brandenburg, refused to hold the entire organization culpable in a huge amount of damages, which the lower courts had upheld because of an incendiary speech that was given by one of its leaders. And it's so good that for those who care about the NAACP and its civil rights work, it's very good that the Supreme Court ruled that way, because that decision, if the lower court decision had been sustained, it would have bankrupted the organization and stopped it from its civil rights advocacy.
The reaction to the decision at the time, not surprisingly, in Cincinnati, where this case originated, that was front page news, Ohio law thrown out by high court ruling. But the New York Times, in its reporting on the case, court voids law on urging violence, put the story on page 13. Was it recognized at the time as being as important as we recognize it today?
I didn't know that about the New York Times. I saw that Law Review commentary, what did treat it appropriately as a very important case. So among lawyers, it was celebrated and recognized.
In our last 20 minutes, we're going to talk about the legacy of Brandenburg. But first, let me tell you what happened to Clarence Brandenburg himself. We really don't know much about the rest of the history of his life. We know a little. He continued to be an angry person. In April of 1971, he was thrown out of the National Socialist White People's Party. In June of 71, he sued the Cincinnati Enquirer over the reporting of his ouster from that organization. And in April of 1972, he was jailed for harassing a Jewish neighbor by telephone. So he continued being a frustrated individual who acted on those frustrations. We talked about a number of cases that have come along since then. We're going to show some of those on screen and talk about how they have continued to evolve our understanding of the First Amendment. But let's take a call from George in Pittsburgh. George, you're on the air. Welcome.
Oh, thank you. Thank you for your series, too. I wanted to ask, which I assume that did any imminent violence actually occur, which from what you say, I'm guessing didn't, and what bearing does that have on the decision?
Well, in this case, it certainly did not occur, and that's also true for, well, actually, as Katie said earlier, in the third of the three cases that the Supreme Court decided, the NAACP case, there was violence after this fiery speech, which threatened violence against people who violated the boycott of white merchants that were allegedly discriminating on the basis of race. There was violence, but it occurred weeks or months after the speech, and therefore the Supreme Court said the imminence standard was not satisfied. But the opposite could be true. If the speech intended to and was likely to actually result in violence, that would satisfy the test, even if the likelihood never actually came to pass.
Pat is in Keyport, New Jersey. Hi, Pat.
Hello. Nadine, maybe you can answer this question. I've read a lot lately about what's been called the heckler's veto, where you say people can't engage in free speech if it's likely to stimulate violence. What about the people who are trying to stifle speech, threatening violence? Where does the original demonstrator, where do his rights end and the other guys begin?
The Supreme Court has recognized exactly what you talk about, Pat, that we do not allow hecklers who disagree with the speaker's message and are offended by it and angered by it. We do not allow them to, in effect, veto the free speech rights of the speaker and of the speaker's willing audience members, because that violates their First Amendment rights. And I think it's really important to note that the Supreme Court crafted that doctrine in the context of the civil rights movement and civil rights demonstrations, where many southern towns tried to stop Martin Luther King and other civil rights advocates from demonstrating, arguing that, well, there are all these people in the community that hate their message, who are threatened by it, who are frightened by it, who think it's dangerous, subversive advocacy, and they were actually throwing bottles and rocks, and the Supreme Court said, no, you have to protect the speaker against the violence. You may not suppress the speech in order to avert violence by hecklers unless there's a breakdown of law enforcement, unless law enforcement is not up to its job.
Stephen is in Weston, Connecticut. Hi, Stephen.
Oh, hi. I'd kind of like to look at the other side of the coin for a minute. We've been looking at Brandenburg as a protection of free speech case, yet at the same time, the court is saying that if you reach some limit, there is a limit, however you express it, a standard by which speech is not permissible. And that's even though the text of the First Amendment doesn't talk about limited speech under any conditions. Could we not extend that approach to the Second Amendment, where so many pro-gun people are saying, well, the Second Amendment rights are absolute, there's nothing in the text of the amendment to limit them, but yet we could cite Brandenburg for saying, well, at some point, reasonable restrictions can be imposed in a constitutional and appropriate way.
Well, we're the First Amendment Institute, not the Second Amendment Institute, so we're really focused on free speech rights. I do think that in the Brandenburg decision, the court has always been clear that there are, the right to free speech is not absolute, and there are certain ways of engaging in speech that are kind of considered just part and parcel of an actual crime. For instance, engaging in speech in furtherance of a fraud or harassment, or in certain forms of conspiracy, your actual speaking, you can still be punished even though the way that you're committing the crime is through speech. So it is not an absolute First Amendment right, but at the same time, the Brandenburg test is a very strict restriction on the ability of the government.
And the analogy you drew between the First and Second Amendment in this regard is exactly what was done by Justice Scalia in his majority opinion for the court, in which he did for the first time construe the Second Amendment as ensuring an individual right to bear arms. Scalia said, and he was very strong on the First Amendment too, he said, just as the First Amendment is not absolute and certain regulations of speech are constitutional, the same is true for this Second Amendment right that we're now recognizing. It also is not absolute. And he actually gave examples of gun regulations that would be constitutional.
1970s were an active time for First Amendment cases. Here are just some of them. Cohen versus California in 1971, where a man was convicted for an obscene jacket protesting the draft in a courthouse. Hess versus Indiana, 73, man convicted of disorderly conduct for cursing at police. National Socialist Party of America versus Skokie, Illinois, a pretty famous case in 1977. Texas v. Johnson, Texas law banning flag burning was struck down. And RAV versus City of St. Paul in 1992, concerning teenagers who burned a cross on an African-American family's lawn, convicted under local hate crime. I added one more, 2017's Mittal versus Tam,
very relevant.
which was a trademark case with a group that was denied a trademark using the name The Slants, and the Supreme Court said that that was a violation of free speech. You've been involved in some of these more recent ones, so what can we learn about how the court's evolving position on free speech has been developing?
Well, a couple of things. One thing that's interesting about the Brandenburg decision is, although it involved the Ku Klux Klan and burning cross, the case really didn't turn on the issue of speech that would be considered colloquially hate speech. It wasn't about the offensiveness of the speech. It was about whether it was likely to cause violence. But the rule established in Brandenburg is part of the greater evolution of the Supreme Court during the 20th century towards, instead of having a balancing test about speech where you weigh the harm of the speech and the government's interest in regulating it against free speech almost equally, that putting the thumb firmly on the scale in favor of First Amendment. And so in all of those cases involving, flag burning, which is considered extremely offensive to people, and an argument that why should we protect that kind of speech, which is so hurtful to people, drawing on the principles of Brandenburg, where you start with, as Douglas says, and I think in his concurrence, free speech is the rule, not the exception. And the cases that we also worked on, which was even sort of in between those periods of time, or that I worked on, involved attempts to regulate video games or other kinds of violent media, and the argument being that, for instance, there were cases arising out of some of the school shooting cases in Paducah and Columbine, where the plaintiffs argued that producers of movies or video games depicting violence should be held accountable for the violence that occurred. And then there were a number of state laws that would restrict the sale of violent video games, and the argument being that this kind of speech leads to violence. It encourages people to act violently. And in a number of courts, and we had argued in those courts that under the Brandenburg case, you can't show that a video game or a movie or a book that depicts violence is intending to incite violence.
One more and our final piece of video for the Brandenburg case, and it features Justice Antonin Scalia and once again Eleanor Holmes Norton, both talking about free speech in our society.
And it sometimes annoys me that when somebody has made outrageous statements that are hateful, somebody says, sometimes the press will say, well, he was just exercising his First Amendment rights. You know, as though First Amendment rights are like muscles. The more you use them, the better. And it doesn't matter what purpose you're using them for. I mean, you can be using your First Amendment rights, and it can be abominable that you are using your First Amendment rights. I'll defend your right to use it. Your right to use it, but I will not defend the appropriateness of the manner in which you're using it now.
I think it's important to understand that the Brandenburg case, for example, it was classic hate speech. It was less about violence than about hate. All of these cases, virtually, which have made the law through the Supreme Court, could all be characterized as hate speech. It's interesting, they go out against minority groups. They go out not against groups like themselves, but they specialize in hate. So hate speech is not only new, it's important to understand that the Supreme Court cases that allow us today to have a Me Too movement, which allow the youngsters in the Enough is Enough movement. Those are the youngsters who are trying to get changes in gun laws, very difficult to get here on the Hill. That all of that comes out of cases that were based on hate speech.
So in our final 10 minutes here, we've got two people on opposite sides of the political spectrum here, both espousing the importance of free speech in our society. What's your reaction when you heard them?
I completely agree with both of them, and with the vast majority of Supreme Court justices in the most recent cases that you listed a moment ago, Susan. The cases have by and large been unanimous or nearly unanimous, despite the ideological diversity on the Supreme Court and the fact that they strongly disagree on other issues. And this is as it should be, because a neutral defense of individual freedom to choose what to say or hear or not, and versus government power to make that decision, as Eleanor Holmes Norton keeps stressing, is something that is to the benefit of everybody. No matter who you are, no matter what you believe, you should have your own right to make these fundamental decisions. And by definition, government is going to be accountable to majorities. So those who have the biggest stake in the long run in free speech are members of minority groups, whether political minorities, racial minorities, other minorities.
Bill is in Portland, Connecticut. Hi, Bill, you're on.
Hi. The question for Nadine, because I think this was an issue that ACLU had some involvement with recently, and this has to do with the Dakota Access Pipeline protests that took place in the Dakotas, where you had protesters, Native Americans, and so, mostly, but people coming from all over the country to protest this pipeline that was affecting could affect the quality of the water supply there. And the protesters themselves were met with extreme reactions from the police and security personnel that were on the scene. You even had journalists that were being arrested. You had elderly people that were being sprayed at with water in freezing weather. It was just you had attack dogs that were on the scene. It was just unbelievable situation, and these were essentially peaceful protesters. And so, in effect, they were being criminalized for protesting. And I also, since then, we've heard that more and more states are enacting laws that would, in effect, criminalize this kind of protest. And so I wanted to get your reaction and thoughts about that.
Well, Bill, you've stated it at least as well as I can. These actions clearly implicate First Amendment rights. And again, The rights exist in theory. It's not until you can get a court to enforce them that they exist in reality, and that's why it's so important to have not only organizations like Katie's and mine, but to have individual members of the community, such as you, who ultimately wield political power. You know, a great free speech scholar in the last century said, in the long run, we the people will have as much freedom of speech as we want. So please raise your voice to your elected officials as well.
So a question, just last week in the Secretary of State confirmation hearings, we once again saw Code Pink on Capitol Hill. The chairman of the committee said he used to be able to have people who were taken out of the rooms have their arrests nullified, but he couldn't do that anymore. So I guess my question is, where does free speech and the Congress and its operations, when they're having public hearings, where's that intersection?
Yeah, I mean, I think they should have allow plenty of free speech and not arrest them or kick them out because of disruption. I mean, obviously you have to have neutrally enforced rules about allowing people to speak, you know, and not being totally disrupted in terms of allowing people to, you know, you don't want to have protesters shout down or drown out the sound of the hearing. But I know that I think it was last year that someone was arrested and prosecuted for, I think, laughing during Jeff Sessions' confirmation hearing, and that seemed, and it was eventually dropped, but that was certainly beyond the pale.
How does the United States do versus our other Western democracies in the free speech area? Where do we stack up?
We have a mixed record, but it's mostly, by my standards as a free speech advocate, positive, certainly in terms of what the courts call political speech, speech about public officials, public affairs. We allow hate speech, which is in other countries is prosecuted. Politicians and even elected officials have been prosecuted and convicted for making general statements about immigrants or racial minorities or women that are expressing a public policy point of view, but it's seen as being disparaging, and that's actually against the law. Where we're not so good as other Western European countries is with respect to sexual expression, where we have much more of a prudish stance, allowing so-called obscenity laws to be enforced.
On Twitter, Katie Fallow, TJ Darnell asks, how much does this ruling affect free speech and social media? We've addressed that, but also asks, is there a difference in written versus verbal hate speech?
No, those types of speech are treated equally for purposes of the First Amendment. And in fact, even some kinds of action or symbolic speech or, expressing yourself physically is also protected as free speech.
Charles in Mobile, Alabama. Hi, Charles.
Yes, ma'am. I'd like to compliment C-SPAN, but I'd also like to compliment Justice Douglas. He was very happy to try to grant me certiorari in my draft case in 1972. As to the lady from the ACLU, very nice lady, I'd like to ask her what she is doing about the inhibiting of free speech at my parents' alma mater at Berkeley, California, for all the conservative speakers that have been banned there.
Well,
I'll take your answer on the air.
Thank you so much, Charles. Well, I wish I had power to control what happens at Berkeley, but I'm doing what I can, speaking on many campuses, including hopefully Berkeley soon. And the whole reason I spent much of the last year writing my book was, which is defending freedom of speech for hate speech, advocating counter speech and other measures to deal with actual problems of hatred and discrimination. But the reason I felt it was necessary was clearly we free speech advocates have not persuaded too many college students and, in fact, too many members of the public. So I hope this book will make the case more persuasively, and the Berkeley students will start showing more respect on the whole for free speech.
You're in a college, university campus. What is your organization doing about campus free speech?
We're actually not directly involved in free speech. We're more focused on speech in the digital age, although our academic focus is very much on bringing together people to look at issues, about sort of new ways to address free speech problems, or questions about whether, for instance, a lot of callers have asked about free speech on social media, and are there arguments about holding social media platforms liable for restricting speech or for allowing speech, either way, either side of the coin. So, I think that is the sort of new frontier of First Amendment, as the court recognized in the Packingham decision last year.
Very quick and final caller from Apollo Beach, Florida. Bruce, we're almost out of time. What's your question for our guests?
Yes, I'm wondering if Brandenburg would apply to silent gestures, such as in the 1968 Olympic Games with Tommy Smith and Juan Carlos when they gave the Black Power sign and they were sent home by the Olympic Committee, and also how that would apply to what's happening in the NFL today with athletes kneeling during the Pledge of Allegiance, or during the national anthem.
Thank you.
As Katie said earlier, the Supreme Court has long recognized that so-called symbolic expression, which intends to and is understood as conveying a fairly specific message, does come within the ambit of the First Amendment. So unless that expression violates the very stiff Brandenburg test, which those two examples do not, in my view, it could not be punished by the government.
So Ohio's Clarence Brandenburg gave us the case that broadly defined First Amendment rights to free speech in the United States. I want to say thanks to our two guests, Katie Fallow and Nadine Strassen, for helping us understand the history and the importance of this case. And as we close, a thanks to our partners at the National Constitution Center for their help on this series. Thanks again.
Thank you.
Thank you.